Hello all, welcome you to the course on corporate laws and governance. In this video, we are going to learn about regulation of combinations. First, let's understand the meaning of combinations. Section 5 of the Competition Act deals with the combinations and the regulation of combinations. Combination means acquisition of one or more enterprises or merger or amalgamation of enterprises which exceeds the threshold prescribed therein shall be a combination for the purpose of the Act. Basically, what we understand from this is combination includes acquisition, merger or the amalgamation of enterprises. Acquisition means acquisition of the control, shares, voting rights as well as assets. How these three terminologies are different from one another? Let's look at that. If it is a merger, two or more companies come together, wherein one company get merged with another company. In the sense, one company will retain its legal entity and the other will lose its form. For instance, the merger between HDFC Bank and HDFC Limited. HDFC Bank retained its legal entity and HDFC Limited got merged with HDFC Bank. In the case of amalgamation, two or more companies join together wherein a new entity is formed. For instance, when PVR and Inox got amalgamated, it resulted in the formation of a new company called PVR Inox. Even we can take the example of Vodafone and Idea Cellular. When Vodafone and Idea Cellular got amalgamated, it resulted in the creation of a new entity, Vodafone Idea. In the case of acquisition, one company would be taking control over another company. The company that is getting acquired is called as a target company. The company that makes the acquisition is called as the acquirer. Normally, the target company would be weaker than the acquiring company. And what happens to its form? It may continue its position as a company, or it may be taken over by the acquiring company. For instance, Tata Sons acquired Vistara Airlines as well as Air India. Both are continuing their operation and they have retained their legal entity. Now let us look at what are all the different types of consolidation that we have. We have horizontal consolidation, vertical consolidation and conglomerate consolidation. What is horizontal consolidation? Here, two or more companies who are in the same line of business get merged, amalgamated or get acquired by another company. So basically, they cater to the same set of consumers. Their production process are the same. The example of the merger of Zee Enterprises with Sony Pictures is an example of horizontal consolidation. The previous examples, what we saw, like the amalgamation of Vodafone and Idea, fall under horizontal consolidation. In the case of vertical consolidation, here what happens? The companies who are in the different stages of the production process or the supply chain, they get consolidated, maybe in terms of merger, acquisition or amalgamation. For instance, we can take the example of Dish TV and the Zee Entertainment Limited. The merger between Zee Entertainment Limited and Dish TV comes under vertical consolidation because Zee Enterprises, it is into broadcasting business, and if we look at Dish TV, they are in the distribution of the entertainment. So they are in the different stages of the production process or the supply chain. So it falls under vertical consolidation. If it is conglomerate consolidation, here what happens, the companies would be falling under different sectors where the business would be unrelated to one another. When they come together, maybe by way of merger, amalgamation or acquisition, we call that as the conglomerate consolidation. If we look at the case of the merger of Sterling Holiday Resorts with Thomas Cook, this is the example of conglomerate consolidation. It is co-generic conglomerate consolidation. If we look at the both are in the tourism business, but if we look at their production process or the type of consumers they target, they are not related as such. So this falls under conglomerate consolidation. Still there is a synergy. So that is why we call it as co-generic conglomerate consolidation. Now let us look at the threshold for filing notice. Whenever a company goes for merger, amalgamation or for acquisition, it is mandatory for the companies to file notice to the Competition Commission of India to get their approval. Not all companies who go for merger, amalgamation or acquisition should file the notice. There are some thresholds which are given by the Competition Commission of India. Here we talk about two types. One is the enterprise, another is the group. What is an enterprise? Enterprise includes individuals, group of individuals or the enterprises who are into the commercial activity. When we say the group of individuals, it could be the Hindu undivided family, it could be cooperatives, any entity which is into commercial activity who have economic objective in their business, then they are called as enterprise. So if it is group of enterprise means, that means two or more companies have control over another company, either in terms of the voting rights, when they are going to have the voting rights of more than 26% in another company, or if they are going to control the affairs of the management of another company, or if they could appoint 50% or more of the board of directors. That means one company has control over another company, and we call this as group of companies. Now let us look at the thresholds that we have for filing of notice for at the enterprise level as well as at the group level. For the enterprise level, there are two divisions. One is those enterprises that have their operations in India. Another is those enterprises who have their operation in India as well as in other countries. If an enterprise is going to be in India only, and if the merger is going to result in the asset of more than 2,000 crore of rupees, or if the turnover is going to be more than 6,000 crore rupees, then these companies should file notice to the Competition Commission of India, and the approval should be got from the Competition Commission of India before they proceed with the consolidation. If the company is going to have its presence in India as well as abroad, that in that case, that company as well as the company that is getting merged or amalgamated or getting acquired, if their assets are going to exceed $1 billion with at least 1,000 crore rupees in India in terms of assets, similarly in terms of turnover, if that company along with its merging company or amalgamating company or the company that is getting acquired, if their turnover is going to exceed $3 billion with at least 3,000 crore of rupees in India, then it is mandatory for these companies to file notice. And when we look at the group level, again it is getting classified into India as well as worldwide with India. If the group of companies are going to have their operation only in India, then if their assets are going to exceed 8,000 crore rupees, or if their sales turnover is going to exceed 24,000 crore rupees, it is mandatory for these group of companies to file notice to the Competition Commission of India to get the approval. If the group of companies are going to have their presence worldwide, then if their assets are going to exceed $4 billion with at least 1,000 crore of rupees in India, and if their turnover is going to exceed $12 billion with at least 3,000 crores of rupees in India, then they have to file notice with the Competition Commission of India, and they will have to get the approval from the Competition Commission of India before they go ahead with the consolidation process. There are some exemptions with respect to the filing of notice. In case the acquisition happens only in India, wherein both the companies are going to be Indian, and if the target enterprise asset is going to be less than 350 crores, or their turnover is going to be less than 1,000 crores, then they are exempted from filing the notice. This particular de minimis exemption applies only in the case of acquisition, not in the case of merger or in the case of amalgamation. Here we are going to look at the asset value and the turnover value of the target enterprise, and if it falls below the threshold level that's been told by the Competition Commission of India, then these companies are exempted from filing the notice and getting the approval from the Competition Commission of India. Now, let us look at the regulations that we have with respect to combination. The first thing is Section 6, Subsection 2 of the Competition Act deals with the procedures that the companies should follow for submitting the notice to the Competition Commission of India. And there are whenever the companies fall above the threshold level that has been fixed by the Competition Commission of India in terms of assets as well as in terms of turnover, they have to file the notice as per the prescribed format along with the prescribed fee to the Competition Commission of India for their approval. When should they do it? There is a time period within 30 days from the date of getting the approval from the board of directors to go ahead with the mergers and the amalgamation, or with respect to if it is going to be acquisition, within 30 days from the date of the agreement with the target company for going ahead with the acquisition, they have to file the notice, and they will have to wait for a period of 210 days. Within 210 days, the Competition Commission of India would be giving their verdict whether this particular consolidation is getting approved by the Competition Commission of India. That they will be getting within 210 days, and based on the verdict, the companies can make a decision with respect to going ahead with the consolidation. In case the company does not receive any communication from the Competition Commission of India for a period of even after the 210 days, then they are allowed to go ahead with the consolidation process. Until then, they will have to wait for the approval from the Competition Commission of India. So, what does this Competition Commission of India does after receiving the notice from the companies that go for consolidation? What the Competition Commission of India goes through the notice, because this particular notice will have information about the merger, amalgamation or the acquisition. So, they will be forming a prima facie opinion prima facie opinion with respect to whether this particular combination will result in appreciable adverse effect on competition. In case they feel this particular amalgamation or merger or acquisition will result in appreciable adverse effect on competition, then the Competition Commission of India will be taking up the further investigation into that particular consolidation. They will be following the investigation procedures that are stipulated in Section 29 of the Competition Act. After inspecting, the Competition Commission of India would be giving their verdict. We call that as order by the Competition Commission of India. Section 31 of the Competition Act deals with the order that would be given by the Competition Commission of India after the investigation into the consolidation. In case the Competition Commission of India feels that particular consolidation results in appreciable adverse effect on competition, they will term this consolidation as void. That means the companies who are involved, who want to take this up consolidation, cannot go ahead with the consolidation. They will have to give it up. Sometimes the Competition Commission of India may feel that the consolidation can go ahead provided the companies who are involved in the consolidation make modifications. The Competition Commission of India would be coming with the appropriate modifications which they want the companies to do. So here what happens, the company should actually do all these modifications, whatever that had been suggested by the Competition Commission of India, within 30 days from the date of receiving these modifications. In case the companies feel that they are not okay with the modifications and they want to make changes in the modifications that had been suggested by the Competition Commission of India, they can go ahead with the changes. So they have to do all the amendments, but they will have to give these amendments within 30 days from the date of receiving the modifications from the Competition Commission of India. And after submitting the amendments, the Competition Commission of India would be looking into the amendments. Either they will accept the amendments. If they accept the amendments, the companies can go ahead with the consolidation process with the amended modification. In case the Competition Commission of India does not agree with the amendments, they reject the amendments, then in that case, the companies should accept the modification which was earlier suggested by the Competition Commission of India, and this should be accepted within 30 days from the date of rejection of the amendments by the Competition Commission of India. So in case they don't want to accept the modification, then the particular consolidation becomes void. They cannot go ahead with the consolidation process, whether it is merger, amalgamation or acquisition. Next, let us look at some of the exemptions that we have with respect to combination regulation. First is with respect to share subscription or financing facility. If one company is going to get control over another company through share subscription or financing facility, then they are exempted from filing the notice. Similarly, any kind of acquisition that happens by a public financial institution, foreign institutional investors, bank or venture capital fund pursuant to any covenant of a loan agreement or investment agreement, then such acquisitions are exempted from the combination regulation, in the sense these institutions need not file notice to the Competition Commission of India and they need not get approval from the Competition Commission to go ahead with the acquisition. But still, there are some procedures. These public financial institutions, foreign institutional investors, bank or venture capital fund should give information to the commission within 7 days of the date of acquisition. Section 6, subsection 5 of the Competition Act deals with this. And here the Competition Commission of India expects complete information from these institutions about the acquisition, like what kind of loan agreement and investment agreement was there, what are all the circumstances that led to this acquisition. All these information should be clearly given by the aforesaid institution, that is the public financial institutions, foreign institutional investors, bank or the venture capital fund to the Competition Commission of India, though they are exempted from filing the notice and getting the approval from the Competition Commission of India. Next, let's get into the concept called gun jumping. What is this gun jumping? Normally in the athletic events, before the athletes run, the gun would be shot. After the gun is shot, the athletes would start running. If somebody is going to run even before the gun is getting shot, then it is considered to be the violation of the rules. So it is a parallel to that. It's been taken from this particular concept. So here in the case of gun jumping, if the companies do not get approval from the Competition Commission of India for the combination or the consolidation, because such kind of combination consolidation is above the threshold level that's been fixed by the Competition Commission of India. So if they fail to get the approval from the Competition Commission of India for the consolidation, then it is said to be gun jumping. This kind of gun jumping is punishable with a fine as per the section 43A of the Competition Act 2002. And how the penalty would be? The penalty can go as high as 1% of the total turnover, or it would be 1% of the assets, whichever is higher of the combination. There are now we are going to look at two types or forms of gun jumping. One is the procedural gun jumping, another is the substantive gun jumping. With respect to procedural gun jumping, when a company fails to notify the Competition Commission of India about the consolidation, then it is called as procedural gun jumping. Here, they didn't even attempt to get the approval from the Competition Commission of India, wherein they fall above the threshold as fixed by the Competition Commission of India. It can happen in two ways. One is to do with the error in computation. Sometimes what happens, the companies who are involved in the merger, amalgamation or acquisition, they may go wrong in the calculation of the assets and the turnover, and they may feel that they fall below the threshold that's been fixed by the Competition Commission of India in terms of assets and turnover, and they may not be going for filing the notice. If the Competition Commission of India comes to know about it, about not filing the notice, then these companies would be penalized. If we look at the case of Avago Technologies and Broadcom Communication, when Avago Technologies acquired Broadcom Communications, they didn't file notice with the Competition Commission of India, and they didn't get the approval for the particular merger, and the reason that was given by the company was that there were errors in the calculation of the assets and turnover, and they presumed that the assets and turnover were below the threshold level, and they could get the exemption from the threshold level. So this was not acceptable under the Competition Act, as a result of which the company, usually the company that makes the acquisition has to pay the fine for it. So here the acquiring company Avago had to pay a penalty of rupees 10 lakh to the Competition Commission of India for not filing the notice due to the error in the computation of turnover and assets. Another circumstance in which procedural gun jumping may happen is due to the misinterpretation of the type of transaction. Let's look at the case of Mangalore Fertilizers and Chemical Company Limited, Deepak Fertilizers and Advance Group. Here, Deepak Fertilizers as well as Advance Group, they were buying the shares of Mangalore Fertilizers and Chemicals Limited in the open market. In the year 2013, Deepak Fertilizers acquired the shares of MFCL to the extent of 24.5% and Advance Group acquired in the same period to the extent of 16% of the shares of Mangalore Fertilizers and Chemicals Limited. The next year, they wanted to acquire more of the shares, but if you look at their shares level, it results in a kind of takeover. As per the takeover code, it is mandatory for the companies to go for the open offer in the market. So, it is a rule for which they have to get permission from the Competition Commission of India. So, both Deepak Fertilizers and Advance Group went for seeking approval from the Competition Commission of India to go ahead with the mandatory open offer as it results in takeover of MFCL. Competition Commission of India in fact agreed to the takeover. They agreed, they gave their approval both to Deepak Fertilizers as well as Advance Group to go with the mandatory open offer, but they penalized these companies for the reason because they made the acquisition in 2013 itself, though these companies claimed that they made those purchases as an investment strategy, not as a strategic move to take over MFCL. But Competition Commission of India proved that these two companies had the intention of taking over MFCL. That is why they went for the acquisition of shares in 2013. So, they should have got approval from the Competition Commission of India in 2013 itself. So, both these companies were penalized for misinterpreting the type of transaction. For them, whatever acquisition they did with respect to the shares of MFCL, they considered that as an investment move, but it was felt otherwise by the Competition Commission of India. They acquired these shares as a strategic move. If it is going to be a strategic move, they should have got the approval from Competition Commission of India in 2013 itself when they started the acquisition of the shares of MFCL. So, here again both the companies were penalized. This also falls under procedural gun jumping. If we look at the next type, which is called as substantive gun jumping. What is the substantive gun jumping and how is it different from procedural gun jumping? If it is substantive gun jumping, companies do submit notice to the Competition Commission of India to get the approval to go ahead with the consolidation. Unlike procedural gun jumping, where they don't even start with the notification process, where they don't submit the notice to get the approval. Here they do submit the notice and they would be waiting for the approval of the Competition Commission of India. But where they go wrong is, even before they get the approval from the Competition Commission of India, they consummate the combination. It could happen by two ways. One is the partial violation of transaction, another is partial payment before the approval. If it is partial violation of transaction, one of the parties to the consolidation would be involving themselves in some kind of partial agreement. They will go ahead with the agreement with another party, which is considered to be the partial violation of the transaction. For instance, in the case of Etihad Airlines and Jet Airways, Etihad Airlines wanted to acquire the equity shares of Jet Airlines, for which Etihad Airlines submitted the notice to the Competition Commission of India for their approval. But before getting the approval from the Competition Commission of India to go ahead with the acquisition of 24% of the equity shares in Jet Airways, Etihad Airlines entered with Jet Airlines an agreement with respect to the usage of slots in the Heathrow Airport. This was considered to be the violation because even before the acquisition happened, they went ahead with an agreement to use the slots of Jet Airways in Heathrow Airport. So, since they involved in transactions even before the approval from the Competition Commission of India, it was considered to be a case of gun jumping, and this falls under substantive gun jumping, as a result of which the Competition Commission of India penalized Etihad Airlines to the extent of 10 million rupees. The next case is with respect to partial payment. When one of the parties to the consolidation makes a payment even before getting the approval from the Competition Commission of India to go ahead with the consolidation, then this is considered to be a case of gun jumping, and it falls under substantive gun jumping. We can understand this through the case between Hindustan Colas Private Limited and Shell India Market Private Limited. Hindustan Colas Private Limited did in fact submit the notice to the Competition Commission of India for its approval to go ahead with the acquisition of Shell India Market. Before getting the approval from the Competition Commission of India, Hindustan Cola Private Limited made a payment of rupees 4 crores, which was a partial payment towards the consolidation. This was since they started with the payment process even before getting the approval from the Competition Commission of India to go ahead with the consolidation. Hindustan Colas Private Limited was fined to the extent of 5 lakh rupees. So basically, if we look at gun jumping, when the companies who are into the consolidation, when they do not get the approval, when they start with the combination process, even before getting the approval, or when they fail to notify and get the approval for their consolidation as they fall above the threshold level, then it is called as gun jumping. Next, let us look at the combination agreements which results in gun jumping. Sometimes when the companies enter into an agreement before to go ahead with the acquisition process, these agreements may have certain clauses which are considered to be anti-competitive. If these combination agreements are going to be anti-competitive in nature, then the Competition Commission of India would be fining the acquirer for this anti-competitive behavior. Let us see what and all fall under anti-competitive nature. If the clauses in the combination agreements, if they are going to infringe with the ordinary course activities of the parties, when we say parties, the target, the target company, if it is going to lead to a reduction in the competition intensity in the industry, if it is going to have the potential of causing competition distortion inter alia by way of the acquirer gaining a strategic advantage over the target enterprise, reducing the incentive and will of the target enterprise to compete with the acquirer, or when it creates a situation similar to tacit collusion, all these are considered to be gun jumping in combination agreements. We can understand this better by looking at few of the cases that had resulted in gun jumping in combination agreements. If we look at the case of LT Food Limited, LT Food Limited, in their combination agreement with their target company, they had clauses like they will be controlling the promotional expenditure of the target company, and the target company should share with LT Food the label, the trademark, etc. And LT Food company would be in a position to interact with the suppliers of the target company. These clauses were considered to be pretty anti-competitive in nature by the Competition Commission of India, because it results in somewhere down the line what happens, it creates a scenario where the company gets a strategic advantage over the target enterprise. So here, though the LT Foods Limited told that they had all these clauses in the agreement as a formality in order to protect the economic value of the target company, it was not agreed by the Competition Commission of India. They felt there was gun jumping in the combination agreement, and they penalized LT Food Limited for this gun jumping in combination agreement. If we look at the case of Adani Green Energy Limited and SB Energy Holding Limited, again, if we look at the combination agreement that Adani Green Energy Limited had with SB Energy Holding Limited, it was considered to be anti-competitive in nature. If we look at the agreement, the clauses, some of the clauses that what they had was Adani Green Energy Limited and the SoftBank could discuss about the operations of SB Energy Holding Limited. Similarly, Adani Green Energy Limited can give advice to the SB Energy Holding Limited with respect to their operation, and it was mandated in the agreement that SB Energy Holding Limited should take whatever inputs that Adani Green Energy Limited gives in their operation. All these clauses were considered to be pretty anti-competitive in nature, as a result of which the Competition Commission of India penalized Adani Green Energy to the extent of rupees 5 lakhs. Now let us look at some of the case laws that we have with respect to gun jumping. The first one what we have is with respect to Cummins Incorporation and Meritor. Cummins had a subsidiary company, wholly owned subsidiary company named Rose New Corporation. Okay, this Rose New Corporation got merged with Meritor, wherein Rose New Corporation lost its identity and it got merged with Meritor. Now Meritor is the company that is in existence. But if we look at it, Meritor has become the wholly owned subsidiary of Cummins for the reason Rose was the wholly owned subsidiary of Cummins. So this is a case of a reverse triangular merger, wherein now Cummins has a complete control over Meritor Limited, and it is mandatory for Cummins to have notified the Competition Commission of India about this particular merger, because this merger between Meritor and Rose has indirectly given Cummins the total sole control over Meritor, which requires approval from the Competition Commission of India, and Cummins did not file the notice and did not get the approval from the Competition Commission of India to go ahead with the particular merger, as a result of which Competition Commission of India penalized Cummins to the extent of rupees 10 lakh. The next what we have is the acquisition of a 9.91% stake in CSE e-Governance by Axis Bank. Here again, Axis Bank did not file notice with the Competition Commission of India for their acquisition of the stake in CSE e-governance. And what Axis Bank told was like, when they computed the asset value and the turnover, and they felt that it was below the threshold level as given by the Competition Commission of India. Since it was below the threshold level, and they didn't file the notice to get the approval from the Competition Commission of India. So it is a case of error in computation. But Competition Commission of India did not agree, since the Axis Bank failed to give the notice due to the error in computation of the turnover and the asset. The Axis Bank was penalized to the extent of rupees 40 lakh. The next case is to do with Bharti Airtel. In 2017, Bharti Airtel and Lion Meadow Investment Limited had 80%, 20% shares in Bharti Telemedia Limited. But in 2021, Bharti Airtel bought the 20% shares what Lion Meadow had with Bharti Telemedia, but Bharti Airtel did not file notice and get approval from the Competition Commission of India for the acquisition of the 20% of the shares of Lion Meadow Investment Limited in Bharti Telemedia Limited. Here the Competition Commission of India felt that Bharti Airtel should have got the approval for the reason that prior to this acquisition, Lion Meadow Investment Limited had control over Bharti Telemedia. They had material influence over the affairs of the company. They could be part of the decisions that was taken in Bharti Telemedia. Because of the acquisition of 20% of the shares by Bharti Airtel from Lion Meadow Investment Limited, now Bharti Airtel has become the sole controller of Bharti Telemedia. So this warranted Bharti Airtel to have gotten the approval of the Competition Commission of India before they went ahead with this acquisition. So the Competition Commission of India penalized Bharti Airtel to the extent of rupees 1 crore. Thanks for listening.